Good morning, ladies and gentlemen. Welcome to today's session. In today's session, we'll be focusing on study unit 18. The topic for today is children's rights. So today we'll be focusing on the children's rights. I'm going to give you a brief review of what is the children's right. A children's right is an important instrument for recognition and protection of children's rights in South Africa, as it is also stipulated in the Constitution. Section 28(1) of the Constitution provides the rights for every child, and Section 28(2) of the Constitution provides that the child's best interest is of importance in every matter concerning the child. So now the children's rights clause, which are relevant to family law, which includes, for example, the right to name. Every child has the right to name, which is supported by the Birth and Death Registration Act. And the surname of a child will depend on the marital status of the child's parents, meaning that, for example, if you are a single mom and you decide to have a child take your surname, or you are married and then both parents decide the child can take their father's surname, or even when you are a single dad, you can also decide that your child takes your surname. So the surname of the child really depends on what the parents decide and their marital status. The second right under the clause, which is relevant to the family law, is the right to family, parental or appropriate alternative care, and the right to nutrition, shelter, health care, and social services. The Constitutional Court in this matter, regarding this right, impose these duties on the parents and family members, and only passes duty to the state when the parents and family members fail to do so. The state is obliged to create necessary environment for parents or family members to provide children with proper care. The provision for legal and administrative infrastructure necessary to ensure children receive the protection according to Section 28. Section 28 of the Constitution. So, and it also affords the family access to land, housing, health care, food, water, social security, subject to available resources. So in the Grootboom case, the Constitutional Court provided that Section 28(1)(b) defines those responsibility for giving care. So Section 28, subsection 1C, lists various aspects and not the various aspects of the child's entitlement. So it only focuses on various aspects, not the various aspects. I will later explain what that is. The list, or rather the rights listed in Section 28(1)(c) are not exhaustive of what it compasses in the Child's Act, or rather in the child's right to care. The court further held that Section 28(1)(c) must ensure the context of the social economic right in Section 25, subsection 5, Section 26, and Section 27 of the Constitution. You are going to need to check this, to refer to this case, just to have an overview and understanding of the decision of the court regarding this uh, this sections. In the case of Mboweni, the Supreme Court held that the right to family, parental, or appropriate alternative care when removed from the family environment is couched as three alternative rights and not as three separate and distinctive rights. And Josti, in the case of Josti, which was heard in the High Court, held that the reference to parental care, a child in the care of someone who has custody over the child. So in this case, the High Court was providing reference to parental care regarding the child, and what the care that it awards the care, the parental care of the child to the person who is in custody of the child. The court further stated that a non-caregiver parent is not entitled to care for the child. However, in the case of Heskey, the court didn't follow the Josti decision, where the court did not give the parental care to the non-care parent. The court in this case extended parental care to step parents, adoptive parents, and foster parents. In the case also of also the court held that the parental care is not restrictive to caregiving parents, and that non-caregiving parents who were divorced were entitled to give parental care. So in the case of also, the court granted parental care to parents who were also non-caregiving. In this case, the parents who were non-caregivers were divorced parents. So the court granted parental care to these parents. Our court held that the child's right to parental or family care must be taken into account in all matters which affect the child, including sentencing. Meaning, for example, if there was if the parents were in a criminal case and the decision of the court would affect the child, the court rather had to consider the position of the child, or rather had to consider the situation the decision of the court would place the child. Meaning, if the child was raised by a single parent and the parent were to be incarcerated, what would the position be for the child? What other steps should the court take to make sure that the child is cared for? Also, when, for example, when the parent is to be deported from the country, the court must also consider the position that it would place the child. A child who is removed from a family or parental care must be placed in an appropriate alternative care. The right to be protected from maltreatment neglect, abuse, or degrading included domestic violence. Enforcement of maintenance and child removal are identified within the family law context, which does not restrict the constitutional rights from the child by from and protecting the child from maltreatment, neglect, or abuse or degrading. What this means is that the maltreatment, neglect, abuse, and degrading, these are the rights provided for in the Constitution. They are also recognized in the family law context as domestic violence, enforcement of maintenance, and child removal. So they are basically the same but identified differently. The third right that we're going to focus on, which is both in the Constitution and in the family law context, is the right to legal representation. Now, in the case of Detroit, the Constitutional Court stated that the interests of the child are at stake and must be fully heard before the court so as to avoid substantial injustice to those children and possibly others. In this case, the court wanted to hear the voice of the child, wanted to give the child an opportunity to be heard in the court so that it avoids substantial injustice or any other problem that might arise as to not giving the child opportunity to be heard or to be represented. Judge Scholler Judge Sola held that the child's view must be heard and given respect and careful consideration. So usually in such cases, for example, if the child has to come through the court for a hearing as a witness or as the case concerns the child, like we have mentioned earlier, whereby the court had to consider the sentence in sentencing the parent, what implications that might place on the child. So that will be also considered also for the child to be represented or to represent themselves, or rather to share their view regarding the case. The paramountcy of the child's best interest. Remember, we did mention how the Constitution in section 28, subsection 2, is for the best interest of the child. So in this case, the best interest of the child is most important. It's primarily what the court would focus on. So in a case where it involves the child, the court will always consider the best interest of the child. So in the past, the best interest of the child were considered mainly in the field of the law. And now they must be considered essential in all fields of the law, be it in a intellectual case or matter, a criminal matter, or an international matter. In the international matter, where we previously mentioned that if a parent were to be deported, the best interest of the child must be considered in that case. Now, speaking of international consideration of the child, we have the United Nations Convention on the Rights of the Children. South Africa is a state party of the United Nations Convention of the Rights of the Children. This means that South Africa has a treaty, signed to a treaty with the United Nations, meaning that it requires, or rather it considers its governance regarding the rights of a child. So as South Africa is a state party of the UN on the rights of the children, it is obligated as a state party to comply with the obligations imposed by the convention. The convention states that the best interest of the child must be primarily considered in all actions considering the child, and that children are capable of forming their own views and must be given the right to express those views in all matters affecting them. So this is also the same as in the Constitution, subsection 28, of where it states that the children's best interest must be considered, and how given an opportunity or seeing the necessity of the child to present themselves or to be heard in the court, that opportunity must be given to the child. We also have the African Charter on the Rights and Welfare of the Child, where South Africa is also a state party to the African Charter. The Charter deals with many rights that are provided for in our Constitution, as we have mentioned previously, also in the United Nations Convention of the Child. It also involves other constitutional rights that our Constitution has. I would say that our Constitution also adopted some of the UN Charter on the UN Convention on the Rights of the Child, and also the African Charter on the Rights and Welfare of the Child. So the best interest of the child is promoted in the Charter, and so are the views of the child in all judicial and administrative proceedings which may affect him. Lastly, the Children's Act of 2005. The rights mentioned in the Act supplements are those mentioned in the Constitution. So you can see now that the Constitution, the UN Convention of the Rights of the Child, the African Charter, the African Charter of the Rights and Welfare of the Child, and the Children's Rights they all have the same rights. They are for the protection and the promotion of the children's rights. The Children's Act seeks to give effect to the constitutional right to family or parental care or appropriate alternative care when removing the child from a family environment, to social services, all the way to his or her best interest. The Act seeks to give effect to the obligation concerning the welfare of the child in South Africa. In terms of the international instruments such as the Convention of the Rights of Children and the African Charter on the Rights and the Welfare of the Child, Section 6 sets out general principles which guide the implementation of legislation relating to a specific child or specific children. So you're going to need to go through your textbook from page 298 to page 300. I can also go through those. Acts. So section 6 is of the Children's Act, not to be confused with other acts. Note that the section 6 mentioned that I just mentioned is of the Children's Act. So section 13 entitles every child access to information on health promotion, prevention, and treatment of ill health and diseases, sexuality, reproduction of his or her health status, and the causes and treatment of his or her health status. So those are the things that are provided for in Section 3 of the Child's Act, allowing the child access to information on health promotion. Now, Section 14 of the Child's Act empowers every child to bring and to be assisted in bringing the matter to court. So this is the same as the one that we just mentioned, where the right to a legal representative. So Section 14 of the Child's Act also promotes that the child can bring a matter to court and or rather be assisted in bringing the matter to court. And the matters that the child needs to bring, that can bring rather to the court, must relate specifically to the children or the child. So I'm going to share on Section 15, which lists the person who may approach the court to enforce the rights which are covered by the Bill of Rights and the Children's Act. Remember, we mentioned how there is a link or connection regarding the four legislation that I just mentioned: the Constitution, the UN Convention on the Rights of Children, the African Charter on the Rights and Welfare of the Child, and the Children's Act. So now we're going to focus on Section 15, which confers by the Bill of Rights and the Children's Act. So Section 15, subsection 1, says that a child who is affected or involved in a matter to be adjudicated can bring the matter to court. Subsection 2, anyone acting in the child's best interest or on behalf of another person who cannot act in his or her own name. Number 3, subsection 3, anyone acting as a member of or in the interest of or class of persons. This person may approach the court. Subsection 4 states that anyone acting in the public may bring the matter to the court that concerns the child. I hope everything was clear. You can also share your questions and your comments in the description box. Thank you very much. That brings us to the end of our session. I hope you enjoyed the session. Thank you.